This is Levi and Salomon's video series on Brazilian antitrust law. On our previous video, we explained CADE's three-pronged test to determine whether a transaction must be filed before CADE. Now, I will explain what happens if parties fail to submit a mandatory filing to CADE's previous assessment and what care should be taken to avoid a behavior that might be considered gun jumping. Parties that fail to notify a reportable transaction or that incur in other gun jumping activities are subject to fines ranging from 60,000 reais to 60 million reais and even to a penalty of nullification of the transaction. Until CADE clears the transaction, parties must refrain from changing their physical structures and competitive conditions. They must not, for instance, exchange competitively sensitive information or exert any influence over the other party's business. Parties should be extra careful when it comes to transactions involving competitors, because besides possible gun-jumping fines, coordination of competitive activities or exchange of sensitive information among competitors can also be considered a cartel violation. When it comes to global mergers, CADE has already ruled against carve-out arrangements. Therefore, closing a merger with a carve-out agreement excluding Brazil from the closing while CADE's review is pending can lead to gun-jumping penalties. In case of non-compliance, CADE will impose penalties based on the status of the transaction, on its assessment of the merits, and on the size of the companies involved. CADE will also consider whether or not the parties acted in good faith.
According to CADE's internal rules, parties may request a temporary and preliminary authorization to close the transaction before a clearance decision is issued. This is an exceptional measure and will only be granted if three conditions are met. First, the authorization must not risk causing irreparable damage to competition conditions in the market. Second, the measures for which the authorization is sought must be fully reversible. And third, parties must demonstrate that there is an impending risk of substantial and irreversible financial losses in the absence of the preliminary authorization. Since the Competition Act came into effect, CADE has only allowed parties to close the transaction before clearance once in 2007. In that case, CADE's General Superintendent had already issued its opinion in favor of unconditionally clearing the merger, but the 15-day waiting period for third parties to appeal against the decision and for any of CADE's tribunal commissioners to request to review the transaction had not elapsed. Finally, it's important to highlight that the Competition Act features a clawback provision, allowing CADE to review transactions that do not meet the merger thresholds we have discussed here. This provision applies up to 1 year after closing, and CADE has only resorted to this mechanism 4 times in the past.